So we have completed 12 topics related to patent. I think this information will be sufficient when you want to file a patent yourself or you want to take help, at least you have some basic idea. So I just thought of adding this extra video to talk about certain patent related court cases, only three of them, because this gives you idea that why patent affects us in everyday life. So let us see this that your patent is very important because it impacts us in different ways. Like first of all, a patent decision can affect entire industry. So it can affect entire industry. It can affect our natural right as a community, and also it can deny us community benefits at cheaper prices. So I'll take one case study for each. So very first case study is about Diamond versus Chakravarti, which is about ethical aspect of patent. So this was a case where it is a clash between the scientific community and the religious belief as well. Can a living thing be patented? So the details are like this: that Anand Mohan Chakravarti, a person of Indian origin who migrated to US, he genetically engineered a new species of Pseudomonas bacteria. Now this is very important that whenever any oil spill happens, it affects a large area of sea, and also it affects the fishery industry, the environment. So then to contain it, like there are oil eating bacteria which actually clears that oil spill. So he came with a new species of this bacteria which does it much better, and he filed for a patent while working as an employee of GE. Patent officer Mr. Diamond rejected the innovation, saying that living things cannot be patented. So this went to up to US Supreme Court, and then US Supreme Court took a view that microorganism organism is nothing but some form of matter, and hence it can be patented. So this was a case where a lot of people got involved. Interestingly, UK's Supreme Court gave judgment in favor of Mr. Chakravarti even before US Supreme Court decided. But then this decision actually made a big difference. The entire biotechnology industry evolved because microorganisms could be patented henceforth. So this decision made a big impact to the industry. We'll talk to second, which is about protection of traditional knowledge. In turmeric, you know that in India we use turmeric for so many things. We use it in cooking as well as for any uh, time we cut our finger with a knife, right? We always use it for healing. So here again, two Indians, Mr. Soman Das and Mr. Haridhar Kohli, they went ahead and they filed a patent in USA on oral and topical use of turmeric powder to heal surgical wounds. After the patent was granted, this became a news item, and Indian government woke up and it was contested. So we took help of our ancient Sanskrit text, converted that into English, and presented that this knowledge existed in this country for ages, and hence these patents were revoked. But then this was a very interesting case because it actually drew attention of many countries that how our traditional right needs to be protected. So this becomes a very important case where which actually made many governments sit up, take notice that traditional knowledge needs to be protected, and it hence it must be documented, it should be digitized, and it should be preserved. Go to the third case, which is Novartis versus Government of India. So this is a patent battle which went on for quite few years. So Novartis actually filed a patent for a drug which they used to sell earlier under license from other country. Now, since India was not giving a product patent, Novartis didn't come for filing a patent in this country, but they took a different route, that they patented this product in other country, and then they started importing that drug in India and selling it. Now this drug was selling in good quantity and at a good price, and then the patent was about to expire. So when the patent was about to expire, Novartis came and said that they want to file a patent for crystalline form of this drug. And by this time, India had moved away from process patent to product patent. So they said that this is a new molecule and we want patent of it. Now this was contested by lot of rights group that this is something an attempt by Novartis to do evergreening. And by this action, Novartis wants to maintain the monopoly for longer period. So this was contested. One major case after India moved to product patent regime for pharma industry, and Supreme Court took a view that company has not been able to demonstrate non-obvious step, that is how the crystalline substance is more efficient as a drug molecule in giving improved result for its patients, and hence this patent cannot be granted. So this was a very interesting use case which was about evergreening of patent by pharma industry and how rights of individuals can be protected. So this was an interesting battle. So these are the three case studies which I thought that I will share with you. I hope you like the entire session, and I have prepared similar session on subject of copyright and then on trademarks. I'm planning to do it on trade secrets also. So stay tuned. You can look at other lectures in this channel, and thanks for watching this.